In this video, I want to take a look at the discovery process in legal proceedings in Ireland. You may have heard of discovery in litigation cases, civil litigation cases, or indeed criminal cases, but I'm going to look at it in the context of civil cases. What is discovery? It's essentially a two-stage process involving firstly disclosure and secondly inspection of relevant documents in a legal case. It allows the parties to know the case that they have to meet. So it allows them to see what case they have to meet, and it allows them to identify strengths and weaknesses in the other side's case and in their own case. For that reason, it may encourage settlement. There are rules for discovery in the various courts, the District, Circuit and High Court. Parties can make voluntary discovery. And if there's no agreement in relation to voluntary discovery, then both parties are free to bring a motion to court to obtain an order for discovery. So what must be discovered? Firstly, documents that are relevant, and secondly, documents that are necessary to deal with the case fairly or to save costs. So those two criteria, relevance and necessity, are vital in terms of discovery of documents. It's not a fishing expedition. Generally, but not always, you'll be relying on inter-party discovery. However, sometimes there could be non-party discovery, depending on the circumstances. So if a non-party to the proceedings has particular documents that may be relevant and necessary to deal fairly with the cost, or with the case rather, well then it may be possible to do non-party discovery as well. So types of discovery then, there's general and there's specific. General discovery is an order for all documents relevant to the issues in dispute in the case, and a general discovery order may be made in the District Court or Circuit Court. However, in the High Court, you must look for a specific discovery order. So you must specify exact categories of documents you're seeking and why you're seeking them. Specific in the High Court because the whole purpose is to try to reduce the costs involved in the discovery procedure, and if it's a High Court case and you're not specifying categories, then there could be a lot of needless costs incurred for both sides. Before going to court, however, the parties should write a letter to the other party seeking voluntary discovery. Only if there's no agreement should you apply to court by way of a notice of motion. The discovery obligation then involves swearing an affidavit, setting out all documents now or previously in your possession in relation to the case. Documents, as I said, must be relevant and necessary to dispose of the matter fairly or to save costs, and no fishing expeditions are allowed. Privilege over certain documents can be claimed, for example, legal privilege, without prejudice statements, journalistic privilege, state privilege, and diplomatic privilege. So correspondence or legal advice from a solicitor to his client would have legal privilege and does not have to be discovered. The timing of discovery then, well, it occurs when pleadings are closed. So the issues should be clear after reviewing the statement of claim, defence and replies to particulars. Once the issues are clear, well, at that stage then discovery can be carried out to identify the exact documents that are going to support or defend a particular case. The terms of discovery then should set out A, the time frame for discovery, and B, the identity of the deponent. The deponent is the person who's going to swear the affidavit of discovery. As I say, it's a two-stage process. Firstly, you're preparing and filing an affidavit of discovery. Secondly, there's an inspection of the actual documents. This could be at the office of the solicitor whose client is making discovery, or alternatively, the copy documents could be sent on with the affidavit of discovery. If mistakes have been made and documents are omitted inadvertently, a supplementary affidavit can be filed. A party cannot rely, however, on a document at trial which has failed or neglected or refused to produce in the discovery process. In personal injury and medical negligence cases, there are extra obligations surrounding the exchange of expert medical reports and obtaining medical records. Statutory Instrument 391 of 1998 sets out disclosure of reports and statements obligations in accordance with the rules of the superior courts. Interrogatories then are questions which can be raised in lieu of discovery or after inspection of the documents discovered. It may be necessary to seek a Moreva injunction or an Anton pillar order as part of the discovery process in order to prevent the disposal of assets or documents. The solicitor has onerous obligations in the discovery process, as a client cannot be expected to know the whole scope of his responsibilities regarding discovery without the assistance and advice of his solicitor. So that's a well-established principle that a solicitor does have onerous obligations in respect of discovery. My name is Terry Gorry. If you like this video, you might give it the old thumbs up down below, and you might be interested in subscribing to my YouTube channel.